And I thought it was saying practice session.
Yep.
Okay, just want to make sure.
Okay. All right. We are now a live Zoom webinar.
All right. Everybody ready? Welcome back. This is day 2, August 13th, 2025, in the evidentiary hearings for docket EFSB 2505, DPU 24152. At this time, we will go back on the record and continue with evidentiary questions as a continuation from yesterday, day 1, August 12th, 2013. First, are there any preliminary matters that any of the parties would like to handle before we begin the hearing, or anything that would need to be discussed outside of the hearing?
Nothing from Trimount.
Nothing from District Gas.
And nothing from Eversource.
Thank you. So I think at this time then we are going to proceed forward. My understanding is that we had concluded with the questions yesterday. The only remaining subjects that would be available for this week would generally be related to zoning and any consistency matters related to policy, Commonwealth policy. For today, I'm actually going to be doing a majority of the questions. So if at any time anyone has any issues again or has any technical difficulties, please raise their hand and indicate that they are having an issue. We will try and resolve it as soon as possible. As before, I will be addressing the panel, and whoever is present from the company that would like to speak, please identify yourself and provide an adequate response. So I'm going to begin just with some general questions regarding zoning. Has the city of Everett expressed any additional concerns that were not previously presented regarding the conditions and mitigation measures for the impacts of the parcel?
No.
So I know that, and just to go a little bit further into it, so as indicated, the city of Everett is not a participant in this matter. There have been additional discussions and conversations with the city, however, regarding this project.
That is correct. Yes.
Could you give us a general idea of how involved they've been as far as in the project? There was some mixed answers that were provided at the public comment hearing, and I'd just like an update regarding the current involvement with discussions with the city.
I believe that Trimount has consistently communicated with the city and worked to understand their concerns. There are different voices in the city. So, we try to work with as many people there as we can. I'm not aware of new concerns that the city has raised at this point. They have indicated a desire for us to continue to work with them as we continue to advance our plans and to stay in front of them and keep them apprised. And we have indicated we are happy to do that.
And as indicated yesterday, there's still an ongoing negotiation regarding the host community agreement?
Yes.
Okay. My next question is, at any point prior to the filing of this zoning petition, did the company make any requests to the city of Everett for any of the variances or exemptions identified? Or special permits?
No.
Okay. And then this is some cleanup that we had from yesterday regarding record request EFSB 1. I had referred to Exhibit TEHM 13, Exhibit TE 1 at 79 through 86, and EFSB Z1 response from the company in IRs. I would just like some additional explanation, or just some additional explanation regarding the timing of the zoning ordinance, of the new ordinance that was updated. I believe that there was two sets of ordinances that were originally filed with the original petition, and then subsequent ordinances went into effect. So just some additional further explanation regarding the timing and the filing dates for the updated zoning requests.
So, Howard Mosier from VHB, thank you for the question. On the timing, it's a little bit uncertain. Members of the project team had reached out to get official copies, and they weren't always available. And despite adoption dates, they're not necessarily posted on a website or official versions. As soon as we were able to obtain the final, that's when we had filed the supplemental testimony. And so there was a little bit of a delay, I think, in getting it properly through the course at the city, and then just getting the official copy, which is common with zoning changes.
So, and just so that we have all of our ducks in a row, the current zoning ordinance for the section that was added was under City of Everett ordinance number C0260-24, and the city has indicated that was adopted on October 28th, 2024, which was prior to the filing of the zoning petition in this matter. Correct?
That was the date, I believe, of proposed ordainment, but not necessarily final.
Do you have do you know of the actual final date? I wasn't able to find it.
I do not know that answer.
Okay.
And
it is your understanding, however, that that is the current zoning ordinance that is in effect and that would apply to this project as of now.
To be granular with the response, thank you for the question. I believe the reference document that I had included as THM 13 is the current version shown on the City of Everett's website.
Okay. And to get even more granular, the updated zoning ordinance is specific to an addition of sections 36 and 37, and is not an update to the ordinance regarding additional sections 1 through 35, correct?
I'm reviewing the first page.
Yep, take your time. This will be most of the questions for today. So, style.
Yes. I'm reading the whereases, Mr. Tar. It does appear that that was only, as written, meant to include 37, 36, and 37, and within it there could be embedded changes to others or cross-references, but.
And it would be fair to say that the updated zoning ordinance would specifically apply to this project, specifically section 37 for the updated zoning, as that is referenced in the first 13 zoning exemptions you're requesting.
If I could ask you to repeat that question, because I think there's a little in it. Okay, thanks.
Yeah. Would it be fair to say that the updated zoning ordinance would specifically pertain to this project, as the first 13 zoning exemptions are categorized within section 37 of the updated zoning ordinance?
I think I could verify the number, but anything that was referencing 37, section 37 was as a result of the at one time proposed and then adopted ordinance. Within that certain zoning, that does make reference that 37 is only limited to certain aspects of zoning and that other sections do apply. So it's not a comprehensive that 37 is the only zoning section. So the remainder refer to the referenced base zoning sections.
So I'm going to now go through the individual zoning exemptions. I do have a couple questions pertaining to each one going through. I will reference them as they appear with their citations in the zoning ordinance themselves as updated. So this would be the anticipated update regarding record request EFSB 1 that would be implemented. So exemption 1 under indicated as land use for battery energy storage systems cited at 37D4C. And maybe I can actually get some clarification before we go through this. The zoning ordinance in some sections, specifically like for parking, makes a separate subsection for a table. In subsection 37D, subsection 4, under subsection C, it indicates there's no additional label for the table. Is that fair to say?
I don't know that specific instance, but there are a number of inconsistencies in zoning in Everett and other communities.
So for now, based on how I read the table and my understanding of the table, I'm going to include it as a subpart of subsection C, so 37D4C, just as far as my references are concerned.
Okay.
If you interpret that differently, please reflect that in the record request for EFSB 1. So first, this is a table of special uses indicating what would require a special permit. There is a specific section referring to, so I'm going to refer to exhibit TEHM 13, also referenced on exhibit TE1 at 79. The current zoning ordinance does permit the battery energy storage system classified as an innovative use. So this would require a special permit, correct?
Under zoning, yes.
Okay. Would the company classify this as a non-master planned use greater than 5,000 square feet or a master planned use greater than 5,000 square feet? There are two sections on the table within the zoning ordinance that indicate separate use, separate non-master or master planned. I'm trying to figure out which one you're indicating.
So I'd like to begin my response by bringing in the aspect of gross floor area, which is indeterminate based on any building inspector or commissioner's interpretation of the proposed improvements on the site, whether they're building/structure or not, on square footage. And that ambiguity lies in many of the reasons why we're seeking the exemptions. But I do believe it to be a non-master planned use. And I believe the use is our project as proposed, not part of a larger master plan. But the applicability of gross floor area is something that we note as subject to either discretion or interpretation.
That was actually going to be my specific next question is how did the company interpret gross floor area? Because that ends up being a factor in a number of different exemption requests. So thank you for the explanation. Is there anything further that or is there any other opinion from the company regarding its indeterminate nature? How did the company guesstimate over 5,000 or estimate over 5,000?
For certain calculations that reference structure or building areas, we did have a difficult time. So we footnoted on page 5 of TEHM 12 some calculations based on estimates of structural footprint. Again, no definition on building as it applies to this use.
I wasn't able to find a definition either. So no fault there. Could you please explain a little bit further why the company didn't choose to pursue a special permit with the city?
Yes, thank you. As I wrote in testimony on page 3 of TEHM 12, the grant of a special permit is inherently discretionary. It's based on subjective criteria. And the Department of Public Utilities has precedent of granting exemptions from special permits.
So it would be fair to say the uncertainty is the reason that you didn't want to pursue that avenue?
Yes, ambiguity, discretionary nature, contradictory zoning references, unpredictable requirements, a multitude of factors, but yes.
Okay. I'm now going to go to the zoning ordinance specifically states, so I'm going to reference the substation section, which is the second part of the table. The zoning ordinance specifically states uses accessory to activities permitted as a matter of right, which activities are necessary in connection with scientific research or scientific development or related production. Where you indicate that the substation is not allowed as an accessory use, could you indicate where the zoning ordinance specifically prohibits substations?
Thank you for the question. I'm looking. In the table of uses, under prohibited uses, there's a line that says industrial plants for generation of power, steam, or any other type of energy.
I'm sorry, sir. I can't understand you.
Sorry, Mr. Brock. I'm looking down while I'm speaking. I believe that was based on in the table of prohibited uses in zoning code, Article 37, there's a line in prohibited uses that talk about industrial plants for the generation of power, steam, or any other type of energy involving the use of solid fuel, and interpreting the ambiguity of this use and interpretation by a zoning official is how we determine that. I may clarify later when I get through the zoning ordinance too.
Okay. It'd be fair to say that this is not a generation facility.
Please allow me to correct myself. I did find the reference.
Okay.
Under the industrial table, there's no table. I'll reference the table. Under the use category table within zoning article 37, under industrial, I did find it. There's a line that says electric generation plants and substation, and it's not allowed unless it's part of a master plan as a principal use.
It'd be fair to say that the substations are an accessory use on this project, correct?
I don't know if that would be fair to say because a substation is an integral part and it could be construed as a primary principal use, depending on interpretation by a zoning official.
So referring to section 37D subsection 4 little b4, determination of use category. Would it be fair to say for specific uses which are not listed but are clearly within a category listed in the table of use regulations, the building commissioner shall determine whether the use is permitted, and if so, into which category it will be classified? Commissioner shall note the applicable use classification in the issuance of a building permit on the EDID. Am I correct that the substation does not specifically appear as a specified use listed, but would be a necessary accessory use, which could be permitted by special permit?
There was Mr. Tar, there was a lot in that question.
There's a lot.
So you cited the reference on the determination of use category. I think you recited it from the zoning code. I just go back to that the building commissioner has the discretion to make the determination, which could be interpreted in a number of ways of how this facility is, what's principal and what's accessory, that it's a project as proposed, and to concern with the discretionary nature of that is why we're seeking the exemptions.
Okay. I'm going to move on to the third zoning ordinance, which is under 37D4 subsection C for industrial operations, either outside or inside the building, which produce industrial noise. Indicated this is not allowed. What portion of the project would create the industrial noise that would be a permitted use as previously discussed with the specific inclusion of a BESS? So because the zoning ordinance specifically contemplates a battery energy storage system, what portion of this project would be classified as industrial noise that is a prohibited use?
Thank you for the question. Just referring to yesterday's testimony that the project is complying with DEP noise ordinances. I further then would refer to the lack of definition on industrial noise in the zoning code. And as noise, which is defined as either inside or outside the building, which we've talked about as being ambiguous in this application, producing noise as an unallowable use, we're going to generate noise that is associated with the activity. And to remove any ambiguity, we're seeking the exemption from this.
And similar to this is going to be a similar question for section. I have them labeled by number. I know that they were not labeled by number. There are 21 requested zoning exemptions. I'm going to use numbers for them. This is number 4.
Yep.
So uses which produce noise or vibrations which are discernible beyond the limits of the property line. Same citation of 37D4 subsection C. Mm-hmm. The ordinance states that prohibited uses which produce offensive odors, emissions, fumes, gases, or smoke, which produce noise or vibrations, which are discernible beyond the limits of the property lines, or which produce dust or waste on the exterior of the building. Is the company's position that the city's position is that the specific inclusion of a BESS as a permitted use by special permit is also a prohibited use?
Zoning Officer Tar, could you repeat that last sentence, please?
So I'll simplify the question slightly. Because the city specifically contemplated the innovative use of the BESS system, is it the company's position that the city is being ambiguous in that it is both a prohibited use and a specific permitted use? Is that the company's position with this, the inclusion of this zoning ordinance exemption?
I would answer that a reasonable person could reach the same conclusion that you made. And further, to support the request for the exemption, there's no definition of discernible on either noise or vibration criteria. And as we all know, people perceive noise differently.
Very true. And then in that line, would it be fair to say that all BES projects create some form of noise beyond the limits of the property line?
I think it would be fair to say that current battery technology or would produce some form of noise.
Okay. Barring some extraneous amount of mitigation.
Or massive technological advances.
Fair to say. Okay, I'm going to go to section 5, side yard setbacks.
Yep.
We're referring to exhibit TD3, which I think is you could also refer to one of the site plans that we were referring to yesterday. That might actually be easier. Could you identify on the northern and southern parcel where the 5-foot and 10-foot setbacks will be indicated?
Thanks for giving me advance notice on the plans. In reference to the side yard setbacks,
Yes.
I refer for the northern parcel you to in TEHM2, there's in subparts, there's a plan labeled C-200N.
Okay.
For side yard setbacks, you will note in very small text on the left side, there's a 5-foot setback, approximately 75% of the way up the western boundary line.
Okay.
On that same exhibit, if you follow from west to east, you would see the 10-foot setback on the eastern side illustrated.
And could you just provide some explanation as to why a larger setback wouldn't be practical?
The site design was established starting with the equipment layouts, whether the substation or battery and auxiliary equipment, which provided for the spacing as discussed yesterday and during testimony, and then applying a roadway width which would allow for operational personnel as well as emergency responders access around the perimeter. So you see the circumferential road alignments on the exhibits, and then providing for a safe shoulder on the other side of the road, which would allow for equipment such as hydrants or subgrade utilities to be located, and then for the construction of the perimeter wall. All these factors in cumulative drove to the alignment of the wall.
Okay. And for my reference, I was citing to section 37D3A, which is where those setbacks are listed in the zoning ordinance.
Thank you.
And in the same citation for the next one, subsection or section 6, rear yard setbacks, the table would require a 20-foot setback. You have requested a 15-foot setback and a 1-foot setback regarding the southern parcel. As you did before, could you identify where those would be and maybe a little bit more information regarding the 1-foot setback? Seems a little tight.
I'm going to refer to you exhibits TEHM2, specifically sheet C200S and C200N. With regard to the northern parcel on C-200N, you'll refer to the setback shown as 15 feet towards the top of the page within the parcel boundary. As we discussed yesterday, that setback was worked in conjunction with the Everett Land Company, but also is a function of the layout of all the equipment. And as you would note, it's a fairly compact and efficient site. To refer to the southern parcel, I refer to Exhibit C-200S. And the 1 foot setback is shown, it might not be even clear, but this site, the southern parcel, has some very unique geometries. It's not rectilinear, and it allows for the benefit of a roadway at this shown as the bottom of the page that allows for service access to Robin Street. That's a very narrow path for the road to travel, and the retaining wall to be safely set back from the road edge does taper towards the property line. And it's a function of the unique access road geometry where there's just not sufficient space to increase the setback.
Okay. We'll move on to number 7, minimum open space. This is under 37D3A. There's a requirement 5% to 20%. There's an indicated open space of only 2.1% on the northern parcel and 2.8% on the southern parcel. Could you identify what is being categorized as open space by the company?
We approximated the open space to be generally those portions of the site that under final surfacing would contain the modest pollinator meadow mix landscaping. We deemed that anything that's within the substation or within the equipment yards encapsulated by the roadways to not be open space. And again, it speaks to interpretation of open space. There's some references of referring to landscape buffers as eligible for this, and that's how we deemed it. Everything else we did not deem to be open space.
Okay.
And further, private roads are excluded and things of that nature. So
When you say things of that nature, what do you mean?
the denominator in the ratio shall include the total site area.
I'm sorry, I can't understand you, please.
Thank you. The footnoted references provide further definition around what the city may interpret to be open space. And it talks about shared use paths, and it also shows about facilities with for passive or active recreation. We don't believe that these areas, aside from the landscaping, planting zones, would be eligible for those criteria.
I'm not going to move on to the 8th one, minimum setbacks, master planned area boundary. You've indicated that there's no master planned area boundary for the northern parcel, and it's not applicable to the southern parcel. Could you explain how a master planned boundary could be established for the northern parcel? We'll start there.
A proponent could propose a master plan beyond the control of the company at any time and establish a boundary.
So would this be Everett Land Co? Is that what, as far as the master plan?
It could be.
I guess I'm just trying to understand a little bit more regarding the master planned master planned area, and the master plan in general, because it seems like the city had some kind of grand idea regarding some larger schematic plan, which it feels like this project would be part of that in the larger scale as far as the shared use for the site, not this site, but this site and the surrounding sites. So is there any intention that this project would become part of some type of master plan filed with the city at some point? And who would be filing that?
I do not know the intention of the city when they drafted this ordinance or how they thought this would all work out. Um, the the reason we're requesting this exemption is due in part to many of the questions that you asked. It refers to intention, not the fact that we have a project before everyone here that is a project that's defined and can anticipate what abutters to the perimeter may do in terms of a master plan or other permitting mechanisms.
And then just separately, why does the exemption not need to apply to the southern parcel? Is it part of some other master area boundary already?
I don't recall why I determined that, but I would go back to it. Um, I don't want to speculate on why I wrote that, but I might get back to you on that, looking through some documents.
Would it be easier to just do that as a record request or follow up next week?
I could clarify that in the supplemental testimony, Mr. Tar, that you had requested.
It may be easy enough just when we take a morning break, just to circle back. And then if we can't do it then do it as a record request. Obviously, your decision on how you'd like to handle it, Mr. Presiding Officer.
I think I'll just have that. I think Mr. Moser's suggestion would be easiest. I will incorporate the request for clarification regarding the eighth minimum setback to master plan area boundary as part of the table presented for record request EFSB 1.
Okay.
So that would be included as part of the initial record request. And that way we can present it as one and make it nice and clean. I'm also not sure that we're going to be getting to a morning break. We may avoid that altogether. So
Even better.
I'm gonna move on to section 9, parking requirements for industrial use, subsection 37D5A. You indicated that there was a required 87 parking spaces for the northern parcel and 71 required parking spaces for the southern parcel. Referring to section 37 D5A, you indicate that this is being classified as industrial use. However, the city specifically indicates a BESS is listed as innovation. Shouldn't this then be categorized as all other uses and required to be determined by the building commissioner based on a similar use in this table, taking into account data as may be submitted by the applicant, so the special nature of the BESS?
Thank you for the question. It points to the discretionary nature of interpretation of what's the primary versus accessory use. And then the discretion of a building commissioner to apply to a similar use, take into account data. Hence the reason why we did provide in the requirements a couple uses that could be interpreted by a building inspector, but that's not necessarily how they would interpret it. So for the illustration of potentially required spaces, we calculated it based on the calculation that we provided, which generated a number of 87 and 71 respectively.
And on the references and the plans that you were indicating before, there are 3 spaces available for the northern parcel and 8 spaces available for the southern parcel.
Yes.
Okay. Maybe I missed the calculation, but what is the gross square footage of the occupied structure used for these calculations? I only see an 800 square foot office building in one corner and a storage unit.
Thank you for asking that question. It speaks to the lack of definition of building versus structure in this unique project. To generate the required number, we made an assumption, again, with the ambiguity in zoning embedded, that the commissioner may interpret the structural platform as building or elements of the substation as building. We assumed a small, modest office on the northern parcel and a container that may be interpreted as office on the southern. But again, all open to interpretation and ambiguity to generate representative calculation.
So it'd be fair to say that you erred on the side of caution and included more than if you had actually pursued a special permit for the exemptions. This is every potential exemption that could be applied, or every potential zoning that may be applied is how you interpreted this.
We made a determination. It may not have been the most conservative, and the building commissioner could, or an inspector, whoever the authority, the building commissioner in this case, could make a determination on their own that would require more parking.
I'm going to move on to section 10, which is section 37D5B4 for transportation demand management. This also goes to the previous section of parking requirements. Was this section included as a precaution but not as an explicit non-compliance?
I'm reading that section, Mr. Tar.
Objection, Mr. Tar, could you just explain what you mean by precaution versus explicit non-compliance?
So if the building commissioner were to make the determination of an all other uses requirement, potentially that would mean that if they made that determination, the parking would be permitted as planned. Therefore, the transportation demand would not need an exemption if they had complied with the all other uses determination by the building commissioner. So there would be an avenue where this would be in compliance.
I've not reviewed, Mr. Tar, all uses in the parking use table. It speaks to places of assembly, restaurants, retail. We can't control the commissioner's determination. But in terms of the transportation, are you on transportation demand management? Sorry.
Yes.
We, as we've talked about the parking requirements earlier and the ambiguity and the lack of clarity, similarly, the requirements of 35 are uncertain and discretionary, and that's why they're included in the exemption request.
Okay. We're going to move on to section 11, location of required parking, subsection 37, or sorry, section 37D5, subsection C. I just like to confirm the location of the parking does not require an exemption and would not need a special permit based on the proposed parking spaces you've indicated.
The requirements speak to the exclusive Parking must be located exclusively at the side or rear of a new building relative to any street right-of-way. Remote parking requiring a special permit. So I'd like to explain that the parking is as shown on the plans, and its proximity to sides and rears of buildings is, again, to the ambiguity on what the building may be applied here. And it also talks relative to any street right-of-way. There may be street rights-of-ways that are established beyond the control of the proponent Trimount. And it also speaks to remote parking requiring a special permit. We are operating a facility that has parcels of land on the northern parcel and the southern parcel, and a building commissioner could interpret parking on the northern side for uses on the south side to be remote parking.
Which would require a special permit.
As written.
Yeah. Okay. We'll move on to reduction of required parking. Section 37D5 subsection D. The calculation for the reduction of parking is based on your calculations of this being an industrial use, not an innovative use, correct? Or other use?
As outlined, yes.
Okay. So, as indicated with the not the last question, but the one before, if the parking is based on a calculation by the building commissioner, it would be possible for the company to comply with the parking requirements if they were modified by the building commissioner.
If hypothetically we were to focus on industrial or office use as a basis for the commissioner to make a determination, the calculations would require more than the 50% authority. Parking spaces may be reduced by the approving authority by up to 50% as a condition to a special permit. So any reduction would require a special permit.
Then move on to section 13 waivers, section 37F2. I just want to confirm the company has chosen not to seek a special permit for the BESS project, although the city of Everett clearly contemplates BESS projects for the city by its inclusion in innovative use in their new zoning ordinance.
I'm sorry, could you?
Yeah, I just want to confirm that the company is choosing not to seek a special permit for the current project, even though the city of Everett in their new zoning ordinance clearly contemplates BESS projects for the city.
I think this particular line item is aligned with the previous discussion points on the nature of special permits as discretionary and subjective, and using the precedent to clean up that.
I understand. I just want to confirm that's the company's position. Section 14, conformity with regulations. This is now relating back to the original zoning ordinance in subsection 3, sub 1. Could you state the specific nonconformities that could not be accomplished by special permit?
I'm referring to that section.
Yep.
Thank you, Mr. Tar. I believe that this list of requested exemptions is a demonstration of items that the proponent has identified in zoning code that are ambiguous, discretionary, subject to interpretation, potentially contradictory with unpredictable outcomes. I think that the question as posed, I'm unclear on if there's anything that we haven't identified that would be of interest.
So I'm trying to get to, is there any of the exemptions that you're currently requesting that could not be accomplished by special permit?
Presiding Officer Tar, just to clarify, are you asking whether a special permit or waiver could address any zoning issues?
Yeah.
Okay, so
I can answer a part of that question. We're going to get to one on impermeable surface that is
I'm sorry, we're going to get to what?
And in page 8 of my testimony on TEHM 12, I describe impermeable surface. I don't believe there's relief under a special permit.
Okay.
There may be others we can touch on later.
We can touch on those. This is actually the next section under 15 is impermeable surface, referring to zoning section 3, subsection 10. I wanted to ask, does the previous use of the site versus the proposed use of the site reduce the impermeable surface by 30%? So if the site was completely impermeable before, are you reducing by more than 30%? Or increasing?
I don't. Thank you for the clarification of your question. The site, as it existed prior to remediation efforts, was entirely impermeable. And as we described earlier in testimony, the site is increasing the permeability with the provision of the green spaces. So it's not producing further impermeable surface.
So would the company be in non-compliance with the impermeable surface requirements based on that interpretation?
If that was the interpretation and we're not producing further impermeable surface, that would be a conclusion. In addition, under the requirements, it talks to any application for zoning approval, which is the trigger for this requirement. And since we're seeking the exemption from special permit, that's why this would no longer be applicable.
Not applicable, meaning that you wouldn't be able to comply with the requirements of zoning. Is that fair to say?
The section simply requires the filing for any application for zoning approval.
Okay. An impact report hasn't, or maybe a better question, has an impact report been completed regarding the impermeable surface for the proposed site of any level?
We prepared the comprehensive stormwater management report, which was discussed at length yesterday.
Yes.
And we spoke to the benefits of the reduction and the rate of runoff and the improvement of water quality, which is a benefit from the project.
Presiding Officer Tar, could you just clarify, are you talking about produces or reduces?
Produces.
Produces. So the end
I'm
result.
sorry,
Sorry, Alan. Produces an impermeable surface of more than 30%.
So
one could argue that the site being completely impermeable before, you are not producing an impermeable surface site now. One could make that argument. I'm not saying that that's would hold water. I'm just saying that's where the argument is coming from. All right, I'm going to move on to section 16, construction commencement. Referring to subsection of the zoning, referring to subsection 3, subsection 15, company is claiming that it is unable to comply with the potential amendments that have not yet been implemented. Is that my understanding?
Could you repeat the question, please?
Yeah, I'll give a little bit more context so that it's a little bit clearer. So the construction commencement indicates under section 3, subsection 15, construction or operations under a building or special permit shall conform to any subsequent amendment of this ordinance unless the use or construction is commenced within 6 months after the permit and construction is continued through to completion as continuously and expeditiously as reasonable. So the company has indicated that if for any reason construction or use is not commenced within the 6-month period, or construction is not continued through completion as continuously and expeditiously as possible, the project cannot guarantee conformity with subsequent amendments of the zoning ordinance. The subsequent amendments we're indicating are the company is saying that it cannot conform to amendments that have not been enacted yet based on potential stoppages the company does not anticipate. I know it's a compound question, but I'm trying to figure out there's amendments that haven't happened yet.
Correct.
You're saying the company cannot conform to amendments that haven't happened yet
without knowing what the future amendments may be.
The company's also, in order for that to apply though, the company would have to stop work or not commence construction.
Thank you. There's 2 points in there I'd like to highlight. It talks a bit about expeditiously, which is subjective and discretionary. And there's potentially a number of reasons that things could be commenced or not continuously. It could be supply chain disruption due to geopolitical events. It could be a force majeure of something. Given that there's the ability for it to be interpreted as continuously and expeditiously, and there might be circumstances beyond the company's control, that's the one of the reasons why this was included as requested relief.
Okay.
In addition to the uncertainty of unknown future conditions of the zoning code.
Then one additional question I had is, when is construction set to actually begin to meet commencement of operations date and deadline of 2028? We talked about that yesterday. I'm aware. We can put a fine point on it if possible.
If you'll hold, I'm going to refer to an exhibit EFSB G1, I believe, subpart 1, which outlined the current schedule that depicted construction commencing in the first quarter of 2026, presumptive upon approvals as outlined, being obtained by the end of 2025.
Thank you. I just want to confirm those dates as far as specifics. I'm next going to move on to section 17, enforcement for permits. Referring to section 9 of the zoning ordinance, this section is specific to whether the company were applying for a certificate of occupancy and does not require conformance, but rather a detailed filing for an application for a certificate of occupancy. Is the company communicating with the city regarding the plan? So subsection 9 is essentially trying to provide information to the city regarding the plans of the building. Has any of this information been communicated to the city? Would there be another avenue for this information to be provided to the city?
In reference to section 9, is that where we are, Mr. Tar?
That's where we are.
Thank you. This section prohibits the building commissioner from issuing a permit for the erection or alteration of any structure or part thereof, unless the plans and intended use conform in all respects with the zoning ordinance. In the language that's written in zoning, it doesn't say it says all respects, not relevant respects. Further, lack of definition on structure and ambiguity therein, which we've outlined previously. But as we've presented in this testimony, written and otherwise, this project is not conforming in all respects with the zoning ordinance because of the zoning exceptions. And therefore, the permits must be based on the DPU order.
One moment, please. Could you point me to the language where in section 9 where it says it has to comply with all respects to the zoning ordinance? I don't see that language in subsection 9.
It's in subsection 9 enforcement, it talks as other information as being necessary to determine and provide for the enforcement of this
I'm
ordinance.
sorry. I'm sorry, sir. I just can't understand you.
Thank you, Mr. Brock. My apologies. In section 9 under enforcement of the zoning code, it refers as part to such other information as may be necessary to determine and provide for the enforcement of this ordinance. It doesn't say of the relevant sections of this ordinance.
So it at no point says what you summarized it to say all sections compliant. It just says information for enforcement.
There's
You
an
can see-
interpretation there.
Okay. Well, my interpretation is that this is for specific maps, information. This is referencing dimensions and radii of angles on the lot, heights and dimensions. Is there another avenue that this information will be provided to the city?
The avenue which this would be provided to the city would be following the conclusion of these proceedings. If the exemptions are to be granted, that would be provided as part of a package for the building commissioner to respond to. I also point to interchangeability in the zoning ordinance between inspector and commissioner as well, inconsistent use.
I recognize that.
Presiding Officer Tar, I apologize for interrupting. Presiding Officer Tar, are you asking whether the company is willing to submit its plans, separate from the zoning ordinance, to the building commissioner?
Separate, yes. Essentially, I'm asking is the information that's requested as part of section 9 going to be provided to the city regardless of the request for an application for a certificate of occupancy? So recognizing that you are not applying for a certificate of occupancy, will the city still be provided all the information that a certificate of occupancy application would provide?
Will they have a record of the plans provided to the city? Okay. We can take that as a record request or get back to you after a break. That's just wanted to make sure I understood the concern that you were looking for there.
We can follow up with it for hearings next week to confirm.
Okay. Yeah.
We don't need to go through a record request for that right now.
Okay.
But my concern is this is a filing requirement. This isn't an exemption that would be necessary other than you are not applying for a certificate of occupancy,
yeah.
Which ironically is section 18, certificate of occupancy. You did put them in a nice order, so they do come chronologically. looking at subsection 10, or looking at section 10, the company doesn't indicate that they're going to be applying for a certificate of occupancy because the company is not applying for a special permit for the project. Is that fair to say? Or maybe a better way of putting this is, why would the company not be applying for a certificate of occupancy?
As written, it's not suggestive that the company's not applying for a certificate of occupancy. It's rather referring to the fact that the certificate of occupancy must be based on the DPU order on zoning exemptions.
Okay. So there's
Again, and I would just further clarify that it does interchangeably talk about inspector and commissioner in references to the determination of use and applicabilities. Those could be two different people with two different opinions, but it all does, after work commences, if there's personnel change, they could make a different determination and not issue the certificate of occupancy. Again, and also with the ambiguity of building and structure in the application of this project. So therefore, the company is saying that the certificate of occupancy must be based solely on the DPU order of zoning exemptions.
Out of curiosity, in a hypothetical, if the company were to be applying for a certificate of occupancy, what buildings or structures would the company be including as a proposed certificate of occupancy? I'm curious if the battery structures, the two-tiered system, would be considered a structure, and the company would need a certificate of occupancy for the entirety of the project, as I'm sure maintenance and service would be part of both levels 1 and 2.
I believe it's an excellent question, Mr. Tar, and one that demonstrates the hypothetical nature of the interpretation around what's building and structure.
So would it be fair to say that the ambiguity would indicate that you would likely have to apply for the entirety of the project out of an abundance of caution, as there would be personnel on the entirety of the site for maintenance that would be considered use of a building or structure?
This is such a unique circumstance. And I don't know if there's and Everett has really tackled this. I think we noted in previous testimony regarding the permit list, there's some interfacing with the fire department on the fire protection system and things of that nature. And I believe that the goal of all this request for relief is to eliminate that question and just say that what's submitted and issued, if there is a certificate of occupancy that ultimately is required, if it's deemed so, it be based solely on these exemptions to remove that line of questioning that you did introduce.
Thank you for your response. That was where I thought we were going. I'm going to turn to section 19, off-street parking. Design of parking lot. So this ended up being a little bit more nuanced, for lack of a better word. Referring to section 17, the term gross square feet means the total occupied floor area within the exterior walls of the building. I don't think that we ended up identifying any kind of gross square foot or square feet in a previous question, but the 3 spaces design requested by the company for the northern parcel, is this so because the company is only requesting 3 spaces, is this why the company believes that this section does not apply. So you've indicated the northern parcel
Correct.
not applicable.
Wait, I'm sorry.
Sorry, Alan. Does the company
So
believe?
you've indicated the north,
So you've indicated that the northern parcel only anticipates 3 parking spaces. Is this why the company is indicating this section does not apply?
For the northern parcel, correct.
Okay.
Can you clarify, are you talking about section 17, section 17A, or section 17O that is referenced in the exemption request?
Section 17O.
Okay.
I will note there is some language that is used in the ordinance that does create some level of ambiguity here. As you indicated, there is the design of this facility is indicated so that there would be access throughout the northern and southern parcel regarding driveways for vehicles. So the way that this section is written for the ordinance, it says design of parking lots for parking of more than 5 vehicles, not necessarily specific to the number of parking spaces, which I would also indicate is actually distinct from the section that is below it in subsection 17, or section 17 subsection P, which is parking spaces over 8, which is included below that. So I just want to clarify, is the ambiguity what creates the need for the exemption in this circumstance?
It's beyond the ambiguity, Mr. Tar. It's also the discretionary nature of a building inspector to review parking plans. And further, the ambiguity even in the definition that you cited in regards to gross floor area or square footage. I can't remember the exact terms. We do have the perimeter wall, which could change interpretation.
Okay. Does the company at any point anticipate more than 5 vehicles on site at the northern parcel?
To be clear, are you talking during operation?
At any point?
I would-
Yes, but during operation, not during construction.
During normal operations, daily operations, normal, no. There would be instances of, routine maintenance and operations where there might be vehicles to perform work, and there might be more than 3 vehicles, but they would have the availability of the access roads in that event.
For parking.
For operations of construction and repair.
Okay.
Not necessarily parking, but use.
And I just want to ask, would any of these spaces need to be in ADA compliance? Or are any of these going to be handicap spaces?
Thank you for the question. We don't believe this facility to have the use office or otherwise that would trigger the requirement for an accessible space, because it's not meant to be normally inhabitable. And due to the nature of the operations, consistent with other projects I've worked on, there's a certain reliance on mobility in the operations of this that don't trigger the need for an accessible parking space, but one could be provided. The grades and space are sufficient.
I'm going to move on to section 20, site plan review. This is under section 19 of the zoning ordinance. This is again sort of a classified as under gross building area exceeding 5,000 square feet. We've indicated that, is the company operating under the assumption that they are greater than 5,000 square feet? Would that be fair to say?
I don't know if that would be fair to say.
Okay.
I believe that we are concerned about the definition of building area and gross building area is defined within walls and structures. And due to that ambiguity, in addition to all the other applicability of special permit, which is embedded in the site plan process, we seek that exemption.
And similar to subsection 9, where I had requested information regarding what would be provided to the city, is the company indicating that it cannot comply with any portion of the site plan review? And what portion could the company comply with for the site plan review as detailed in section 19?
Mr. Tar, could you clarify whether you're talking about submitting plans or allowing standards set based on the plan submitted?
So it's somewhat twofold. Section 19, subsection B, indicates 19 different identifies 19 different points of information regarding location and dimensions, topography, buildings, parking, external lighting, utilities, and that would have to be completed in duplicate and provided 12 copies to the city. I'm trying to find out which portion of the site plan would be provided by the company in the indicated providing of information that we had talked about before, and what the company would not be able to comply with.
So I think just to clarify, is it the simple submission or there's discussion of approval of the site plan review and what conditions could be added to that? Which of those two are you asking, Mr. Mo?
I guess I understand the distinction. So I would ask what, as far as the information that's being submitted, could the information that's being requested as part of a site plan be provided by the company separately from a site plan review request and approval, understanding that there are subsections that the company would not be able to comply with as far as the zoning ordinance? Potentially.
I apologize, go ahead. I was just going to say, so separate from the planning board's ability to amend all such submitted plans based on the following criteria. So similar to what you asked before of the simple submission so that the city has the plans that the company will be working off of.
Yes.
Okay. No, I think we can get back to you on that, similar to the earlier request for the next week of hearing.
So we'll incorporate that. Would you like to incorporate that into the record request, or do you want to just provide an update when we come back on Monday?
I think that would be easy enough addressed during the next hearing day, just simply saying whether or not the company intends to submit those plans.
Okay, we'll follow up on Monday. That'll probably be at the end after safety.
Okay.
Just as a
And if I could just add quickly, there's a lot of language in Article 19 about adequacy without criteria and the subjectivity of site plan review, which is discretionary and based on very subjective criteria. So there's.
Okay. I think what I'm looking for, what my expectation is, I just like to know what will be provided to the city and what will be included as far as what they typically would receive for a project or a planned building. Would they still be receiving the same information, even if they're not being requested to provide approval? Just so that's my expectation for what I'm looking for.
Thank you.
We'll go to the last section, which is stormwater management and land disturbance, which is section 28. This ends up referencing the disturbance of an acre of land, of an acre or more of land. I guess I'm trying to understand, does the company anticipate that the construction of the project will result in the disturbance of an acre? How does that interplay with the remediation that's going on site? And would disturbance be more appropriately directed to the current remediation company as far as the stormwater and land disturbance?
Thank you, Mr. Tar. You raise an excellent point regarding the activities of others that aren't the company. The requirements of a separate permit with the detailed procedural and substantive requirements does reintroduce the discretionary nature of approvals at different forums within the planning board. The company has offered, as we noted yesterday, to prepare an erosion and sediment control that meets industry.
I'm sorry, to prepare a what?
An erosion and sediment control plan that will meet industry standards.
And as before, the erosion and sediment control plan that will be provided to the city, the request is that you would not need to require the permit from the planning board. Is that fair to say?
Yeah, it's fair to say that TriMount will not apply for the permit, and nor will it meet the procedural and substantial requirements of the section.
Would it be fair to say that the erosion and sediment control plan will be provided to the city?
Yes.
Okay. And or planning board. I'm including city and planning board together.
Yes.
Now that we're done with the specific zoning ordinances as far as individuals, I did want to move slightly to some more general topics regarding the comprehensive zoning. If you could refer to TE1 at 96, which is the initial petition at page 96. Could you provide an update as to how a comprehensive zoning exemption could avoid substantial public harm by serving to prevent and delay in the construction and operation of the proposed use, given the updated zoning ordinance provided by the city on dated October 2024?
Could you recite
the
reference?
TE1, which is the petition.
Yep.
At 96. Maybe it's.
I may have ran out of paper. I didn't sponsor that petition, so.
That's the initial petition. That's the petition for that. I don't know if that was cited to you. Let me pull that up.
I don't think it's cited to anyone. In many ways, it's more of a legal argument.
Yeah. It is more generalized. I'm just looking for more general information regarding what would be the benefits of a comprehensive zoning exemption for the company at this point, given the new updated zoning ordinance.
Mm-hmm.
If you allow me a moment, I could try to find that reference and see if I can provide assistance. And I did run out of paper at page 45. My apologies, Mr. Tar.
No worries.
So to make sure I understand the question you're asking, essentially, why does the company need to apply for a comprehensive exemption when there has just been this amendment?
Yes.
Okay.
That would be a fair summary of my question.
Okay.
I have the file opening. And you said page 95?
96.
96, close.
It ends up
approximately page 95.
For clarity, what I'm citing to is actually the standard of review generally used for comprehensive zoning exemptions. I'm asking its effect for the new zoning ordinance.
Whoa. Sorry, I've got a, no, I
No.
don't. I thought I had a fire alarm, but it just went off for a second. Thanks.
Scared me, Alan.
You too.
And for context, not interrupting the question, but this will be an issue that we address on brief.
Understood. And that would be my expectation too.
Mr. Early, Mr. Tar, are you looking for input here?
I think there's a pending question for either you or Mr.
Okay.
Detweiler. Yes.
So, if and Mr. Tar, thank you for the question. I would say that as you've become familiar with zoning and Everett zoning in particular, as well as the testimony we've prepared, there are a number of ambiguous and contradictory sections of zoning that make determinations at any reasonable time frame difficult to ascertain with uncertain outcomes of reviews, just that things could change in the future beyond the control of the company. In terms of many of the elements that we are requesting the exemptions for, in terms of noise, the project's complying with the DEP noise ordinance. We've described the stormwater benefits of the project. We've talked about traffic. To provide clarity and to be consistent with the department's previous exemptions and precedent set, that's supportive of the request.
Thank you. I'm now going to refer to Exhibit TEHM 13, which is the updated zoning ordinance references the development of a master plan. We had previously discussed this as part of the testimony today. Could you please describe any efforts the company made regarding the development discussion and the decision to not pursue a special permit or develop a master plan which would include the project?
Mr. Tar, while we're waiting for Mr. Moshe to answer, I just want to point out before you were asking about the dates of enactment. If you go to the final page of TE-HM-13, it has that information of when it was presented to the mayor and when the mayor signed.
Thank you, Mr. Earl. As a amendment to record request EFSB 1, only because it's an issue that I ran into while doing my research, would the company also be able to provide an updated copy of the zoning ordinance in a searchable PDF? The PDF that was provided is non-searchable. Could that also be provided as an update with the table being provided as a response? So that would be record request EFSB 1. You can have that as supplement 1. So parenthetical 1.
We can certainly ask. Whether we're able to get it is a different thing. And this will be included in our response. And it may just be a situation where we have to try to OCR the document as compared to having a file that makes it more effective to actually do searches. No, it's very challenging to work through the certified copy they gave us.
Understood. Just have to ask.
Yep. No, I will add that in.
So with regards to master plan development and the processes associated therein. It everything in general, the master plan process points to a special permit, which leads us to many of the exemptions that we requested today. And it further talks about design guidelines and regulations that the planning board shall adopt, and from time to time could amend regulations to the design of open space, building design, roadway layout and design. There's embedded in the process of a master plan above and beyond just a special permit. There's embedded ambiguity, discretionary natures, which further supports the requested exemption.
In sticking with a potential need for a comprehensive zoning exemption, could you expound a little bit more regarding good faith communications with the city of Everett and what levels of government you've been able to speak with and talk to since commencement and pre-filing for the project?
Sorry, can you repeat the question?
Yes. So in sticking with the comprehensive zoning exemption request, could you please provide additional information regarding the good faith communications had with either the city of Everett and what level of government within the city of Everett you were able to speak with and discuss for regarding the project?
Sure. We've had numerous conversations with Mayor DiMaria, with Matt Latanzi, the planning director, with the city's external counsel, and others at the city about our need for a zoning exemption and our intent to pursue a zoning exemption through the EFSB. And, you know, we notified them when the process was beginning, and so we've constantly kept them up to date. The last time we met with the mayor and Mr. Latanzi and others was in early July, and we indicated in the course of that conversation that this case was proceeding, and they were aware of that.
Did they express any opinion regarding your pursuit of zoning exemptions? I would ask them, but they're not here.
Right. They understood that we had previously decided to go the EFSB route, and they were not disputing it in any fashion.
Okay. And could you, I know that we've had a lot of discussions about it, and I know that it's currently ongoing. Could you provide just a status regarding the host community agreement and any anticipated resolution that you see? Is that something that would bleed into next year? Is that something that you anticipate resolving around the same time the EFSB case resolves? Just some additional information if possible.
If you'll refer to my response to data request EFSB G2, we provided a record of all of the or a lot of the communication between us and the city about the host community agreement. We've provided them a draft. They have indicated that they have it under review and will provide it shortly. We're committed to working on one with them when they provide a returned copy.
Is there any expectation for when they should get back to you?
They have indicated shortly.
In the past, has shortly not been shortly?
They have been indicating shortly for an extended period of time.
Okay. I also wanted to get some general background information regarding Jupiter in general. How many battery facilities does Jupiter currently own or operate?
For clarity, are you talking about projects in development or operating projects or both, Mr. Tarl?
I'd ask that you can make the distinction. So how many are currently in operations and how many are currently in construction, and then how many would potentially be in active development, understanding there may be some confidentiality that you may be pertaining to that.
There are, I believe, best of my knowledge, 12 currently operating projects. There is at least one project currently under construction, which is in California. And there are numerous projects totaling over 10,000 megawatts at least of projects under development all across the country.
Are the projects exclusive to the United States or are they abroad as well? Is Jupiter international?
All of our development and operating projects are in the United States.
Okay. To date, of the 12 operating projects, has there been any significant issues regarding safety or operations for the 12 that are currently in operation? And some of this may pertain to next week, so.
Significant is an ambiguous term. Jupiter Power has not had any fires at any of our projects, if that's what you're asking.
I guess just in broad terms, what's the oldest project currently in operation for Jupiter?
I'm not certain of the answer. I would need to check.
Well, in broad terms, is it 10 years, 20 years, 30 years?
Would have been approximately 2020 or 2021.
Okay,
Would have been the
so
first project.
4 to 5 years. It would be a good answer.
Approximately.
Approximately. And only to ensure that there isn't any long-term, because of the new nature of the company, is Jupiter's parent company backing Jupiter in a way that there would be no chance or is Jupiter insured in a way that it would be able to financially support itself in the event of an issue or fire at any of its other facilities? Trying to make sure
Yes.
the company doesn't go under before middle of construction.
Yes, we have an excellent relationship with our insurers, and we are well insured.
Is Jupiter owned by another company? Is Jupiter part of another company?
Jupiter Power is owned by an infrastructure fund that's affiliated with BlackRock.
Okay. And then I just have a couple more questions, and that's why we're going to just push to finish, Alan, if that's okay. I don't have that much more.
Could I ask how much that is?
10 minutes
Okay,
at most.
sure, thanks.
So I just had a couple questions regarding, has any of the current green energy federal programming and federal changes in policy affected the project moving forward? Specifically, they're moving away from green energy.
So the question is very broad.
It is.
The recently passed federal legislation included only very minor changes to the tax credits that batteries are eligible for, the investment tax credit that batteries are eligible for, which is an important piece of our financing. So there's no major change to that important piece. There are a lot of moving pieces in federal policy right now, so I could be more specific if you had more specific questions.
And I may follow up on Monday with some more specific questions. I just want to go in broad terms, at least for right now. Has any of the current economic climate caused any supply chain issues for the company regarding the procurement of batteries for the project?
You're asking about this specific project, Mr. Tar?
This specific project, yes. Or at least the petition indicates the use of lithium batteries. Lithium would be a company that is based out of China. Has that caused any significant issues for this project? Or could you please describe how that has affected the project to date and how it would anticipate it affecting the project moving forward?
Thank you, Mr. Tar, for the clarification there. Jupiter Power has not yet selected the equipment, and so that determination is still to be made. Hyvium is one of the companies whose equipment we are considering. There are a number of other companies as well. Some of those companies are actively planning, or at the very least planning, production facilities in the United States of America that would be online in time to provide equipment for this project with our COD. If that were to occur, then that would significantly address some of the important issues associated with recent federal policy changes.
And out of curiosity, when would the company anticipate securing the contracts or making the determination for what batteries this facility would end up using for operations?
The company would intend to make final equipment selections after the contracts are finalized. Contracts meaning potential Clean Peak offtake contract, the Clean Peak credit contracts through Department of Energy Resources, and would proceed very, very rapidly at that point with final engineering.
Because the final equipment selection hasn't been made yet, are there any aspects of the design of the project that would be affected by the equipment that's being selected? So for the batteries themselves, I'm sure that they're not all exactly the same.
Yes.
Could you give in general terms, what aspects of the project design would be affected? I don't know what 3 different battery suppliers could potentially provide or what the differences would be. could you just give me a little bit more information on what you would foresee being?
Sure. So the company has not yet procured the equipment, and the company is evaluating the equipment on the basis of what may become available in the future. I will refer you to my data request response to EFSB SH27, where we provide a new layout that the company is considering, which is based on containers that are container structures, battery structures that are more recently developed than what we originally submitted with our original application and the petition. And in that data request response, we note that, and I'll just read from it, a key portion. The latest model BESS units could reduce the number of containers on site from approximately 816 to approximately 560 units. So the specific equipment that would be available for final design can have a significant impact on the layout and the specific engineering.
If the updated, or if the newly developed technology that you indicate is possible would become available to the company, that would then have a subsequent effect on any requests for zoning as well as structural design of the site and fire safety.
Sorry, I just note that under the EFSB standards, if there's a material change, we need to notify the EFSB of that change and then deal with it in that circumstance. So kind of beyond what they are, that's really the standard going forward. More than that would be speculating on what the impact could be. The equipment chosen could allow the exact design. It could be a change, as Mr. Detweiler noted.
And maybe a better question would end up being, I'm more concerned if there ends up being, if the company had the choice between choosing a battery, an older battery that would comply with the current or with the proposed acceptance from the EFSB versus a new battery that would trigger a project change, does the company have a preference on which route it would go down?
In that instance, that would be one factor of many under consideration. So it's difficult to speculate as to an answer.
Understood. I'm not going to belabor the point. I was just curious.
Yeah.
Before we say goodbye for this week, does anyone from the EFSB panel or any of the interveners have any additional questions or follow-up based on my questions of the company or the panel? We can go in order. EFSB first. Any additional follow-up from today or yesterday? If we do have follow-up, I will note that we would need to take a break and come back and do follow-up. All right, seeing and hearing no response as of now. Is that fair to say? No? All right. At this time, I'm going to conclude today's hearing. There is some
Mr.
procedural.
Tar, I apologize for interrupting. I would just note no.
I apologize. Redirect, Mr. Early.
There is no redirect.
My apologies. I jumped right in there. I just assumed. So, all right. At this time, as we had, as I may have signaled and previously discussed, as of right now, we have 5. There are currently 5 record requests that have been indicated. Record request EFSB 1 regarding the updated zoning exemption request as detailed today and yesterday. Record request EFSB 2 regarding exhibit TE1 at 52 regarding the 3 projects, their owners, size, operations, names, and additional information. Record request EFSB 3, additional mitigation considered regarding noise, as well as additional cost of additional mitigation. Record request EFSB 4, the noise protocol the company would recommend for confirmation testing of noise as part of operations. And record request EFSB 5, other technologies that are emerging or might be used in other cases as related to SF6. I am going to, as of now, indicate that record responses, because of the gap in the hearing schedule that we have currently, that record responses would be due next week on August 20th, prior to the following week's hearings. And then we can potentially follow up on any of those record response requests as part of the hearing next week, if necessary. Does anybody have any procedural matters or other issues that they would like to discuss before we adjourn?
Nothing from the company.
Nothing from District S.
And nothing from Eversource.
Thank you very much, everyone. At this time, we will go off the record in EFSB 2505, DPU 24152. We will, out as a separate matter off the record at this point, we can go off the record, Alan. There had been floated the idea, because we may end up trying to resolve everything on Monday regarding fire safety as well as EMF. The anticipated plan is to do EMF first and resolve that as we did with the noise discussion, and then move forward into fire safety and any follow-up questions that we may have. The goal would be to get through the remainder of the hearing on Monday without having to go through till Wednesday. That may or may not happen. I just wanted to know if anyone had any opinion regarding, and Alan, this goes to you too. Anyone had any opinion about starting at 9:30 instead of 10?
Fine with me.
Fine with the company. We're willing to start early and stay late if needed to get through everything.
That's fine with District S.
And Eversource.
Okay, so we will come back then at 9:30 on Monday, not this upcoming Monday, the following Monday. So I will look forward to that. And let me just double check, make sure no one's saying anything. Okay. All right, I will see everyone, not this Monday, next Monday. I look forward to your responses, Mr. Early, and I hope everyone has a good week, and we will see you when we return.
Take
Thank
care,
you,
everyone.
Alan.
Thank you, Mr. Tar.
Thank you.